No, you're doing B and C, yeah.
It's recording, right? You're going first?
Yeah.
Okay.
Okay.
At your own time.
Good evening, Mr. Arbitrator. My name is Seah, and I'll be speaking on behalf of the respondent, the Games Disciplinary Committee, hereinafter the GDC, on issues A and D, addressing Mr. Lendert's issues on appeal. My co-counsel, Mr. Brendan Zhang, will be speaking on issues B and C, addressing Ms. Tang's issue on appeal. We respectfully reserve 1 minute for a rebuttal. Sir rebuttal. This case is not about sympathy for one athlete or the popularity of another. It is about upholding the rules of integrity of the qualifying games. The GDC acted within its mandate, applying the governing rules and principles to protect fair competition and to ensure that the games are conducted without illegality or undue advantage. The decisions of the GDC are founded on concrete facts and established laws, and we seek that this tribunal uphold our rulings. With
Why
that,
do you say it's concrete facts and established laws, also?
I will establish that as we go along, Mr. Arbitrator.
Okay.
With that, I make two submissions addressing Mr. Lendert's claims. Firstly, the GDC's quorum was not biased in coming to a decision, as both Ms. Farina and Mr. Douglas are independent and impartial arbitrators. Secondly, the GDC did not err in finding that Mr. Lendert has been liable for doping. Blue Bat, in its nature, is a performance-enhancing drug. Turning to the first issue, Mr. Lendert is challenging the constitution of the GDC, alleging that there was bias. While the appellant may seek to rely on Rule 33, to determine if an arbitrator can even be challenged, they should be relying on Rule 34 instead. It notes that an arbitrator may be challenged if the circumstances give rise to legitimate doubts over his or her independence. This threshold of legitimate doubt is similarly noted in Article 180, Part 1c of the Swedish Federal Act on Private International Law, henceforth the PILA. The reason why we can rely on this is because the court, in its 2010 decision of Besquet Minora and Valdemar Bosa, cited and applied Article 171 of the PILA in determining arbitrarity of a dispute. Furthermore, the threshold of legitimate doubt can be found in similar wording in the Malaysian Arbitration Act section in related cases. In the 2020 case of Sanyang and World Anti-Doping Agency, it noted at paragraph 6.5 that there must be concrete facts objectively giving rise to the lack of independence. In that case, the panel's chairman, Mr. Franco Frattini, possessed an innate bias against Chinese citizens as shown from his tweets. To read one for Mr. Arbitrator, it noted that torturing innocent animals is a flag of Chinese sadics, inhumans, with the protection of Chinese authorities and the tolerance of Western powers focusing on more business with China. Notably, this tweet, amongst the pattern of other tweets, goes to show that there's a concrete facts relating to the lack of independence of the arbitrator. Ultimately, this led to the Federal Tribunal to annul the CS award and challenge Mr. Franco Frattini. In our case, there's no concrete facts that will give rise to the lack of independence. Ms. Farina is merely Ms. Tang's cousin sister. While there's a blood relation, there's no evidence that details the closeness of their relationship beyond this familial link, suggesting that it might not inherently compromise her ability to serve as a commission member. While Ms. Farina had provided on-the-side coaching, this is simply a temporary or consultative advisory role, which is potentially a limited professional engagement rather than a long-standing, career-defining partnership they will make her dependent on Ms. Tang's on her team.
But does it really have to be a long-standing professional relationship for there to be a finding of bias or apparent bias?
No, Mr. Arbitrator, and I'll cover that in my second issue. Would you like me to address that now, Mr. Arbitrator?
No, yeah, I mean, finish with your submissions on this issue first.
Okay. With regards to Mr. Douglas, the professional interactions such as the fan meetups where both Mr. Douglas and Ms. Tanks were spotted are typical of public figures in the esports realm, and they do not indicate a privileged or adversarial relationship that will compromise his judicial capacity. The one-time special and personal sharing session was an event that took place 6 months prior to the tournament. A single historical event, even if it led to them being in contact since, does not establish an ongoing dependent relationship that will necessarily sway his judgment. Turning now to Mr. Arbitrator's question, we note that even if there's a finding of a relationship, there must still be ongoing economic ties or ties that have ended recently to demonstrate a lack of independence. This was noted in the case of AVB, heard in the Federal Supreme Court of Switzerland for Civil Law Chamber. The reason why we can rely on this case is because the International Olympic Committee, it's because this was created by the International Olympic Committee, and it operates under Swiss law, specifically the Swiss Private International Law Act, because its seat is in Lausanne, Switzerland. At paragraph 2.2.1 of the case, they emphasize that impartiality and a lack of independence is only found if there's ongoing economic ties or ties that have ended recently. It noted the facts that a relationship that ended approximately 12 years before the arbitration request was introduced, and it ultimately concluded that this 12-year gap, combined with the fact that the recurrent A was not a formal party, but merely the administrator of a company involved in a previous litigation, showed insufficient economic ties or past economic ties. In our case, the fact pattern they have provided with is shown that there's clearly no economic ties between Ms. Farina and Ms. Tanks, as they are merely distant family members, in which Ms. Farina only acted in the capacity of a coach. With respect to Mr. Douglas, there's only a coaching relationship as well. While their relationship got closer, there's still no evidence of any economic ties where Mr. Douglas will have a profit in ruling or favor in Ms. Tanks.
I don't know whether you can use that as a rule rather than a factor. I'm sure in that case that you're citing, economic ties are used more as a factor rather than a bright line rule. And here we simply don't have anything in relation to they are economically linked or what. What we have here is recency of time of interaction, which I think it was 6 months you mentioned, and there were ongoing events or occasions where they were seen together. And also, I mean, it does say that event at paragraph 26 of the record that Mr. Douglas and Ms. Tang's relationship eventually got closer after the sharing session. So why is this not an appearance of bias? I mean, this seems very much like appearance of bias to me.
Mr. Arbitrator, we note that on the fact pattern, this can possibly lead to the appearance of biasness. However, we would like to if Mr. Arbitrator is not with me on this case, we would like to bring you to the issue of a lack of disclosure on both parties. In that case, a lack of disclosure does not amount to a finding of impartiality or a lack of independence. In the case of A and International Federal Association of Football, the challenge arbitrator, Mr. Mark Hovel, regularly failed to disclose information regarding past cases where he served as an arbitrator. However, it was found while such non-disclosure was found to be inappropriate and contrary to the requirements listed as you're concerned with, Mr. Arbitrator, nothing indicated that this practice was a deliberate intent by the arbitrator to conceal the information. In our case, there's no deliberate attempt by either Mr. Douglas or Ms. Farina to conceal their prior relationship to the court. Crucially, Ms. Farina's reasons for the lack of disclosure was because she figured that it was already public, as seen from paragraph 27 of the facts, suggesting an absence of intent to intentionally hide the association. Mr. Douglas, on the other hand, has been previously an online streamer and an avid gamer, and has been on occasion seen with Ms. Tanks in fan meetups. Given that the initial connection between Mr. Douglas and Ms. Tanks including his public role as a gamer, were already in the public domain, such notion that either party maliciously tried to conceal their background relationships from this court is undermined. And ultimately, there shouldn't be a finding of lack of independence or impartiality. Turning now.
But doesn't the CAS code require any disclosure of an arbitrator's prior connections or relationships or interactions with the parties?
Yes, Mr. Arbitrator. And in the case that we noted, even though the Mr. Mark Hovel had failed to meet the obligation to disclose, they still found that he was still sufficiently independent and impartial arbitrator. A lack of disclosure does not automatically mean that an annul has to be award has to be annulled. Turning now briefly to our last issue, we submit that Bluebet is not a we submit that the GDC acted within its jurisdiction and direction under the qualifying game rules. Rule 7 of the qualifying game rules define doping as the occurrence of more than one doping anti-violation set forth in a WADA prohibited list and a WADA code. And Rule 13 instructs the and Rule 12 defines a prohibited substance as any substance or method contrary to the spirit of the sport. This clause grants GDC the residual discretion to protect sporting integrity even for unlisted or newly discovered substances. And notably, this was noted in the 2004 CS case of Maria Louis Kelly Williams, where the tribunal accepted that an unlisted substance could still fall within the scope of the code if it exhibited similar pharmacological effects or violated the spirit of the sport. Professor Caitlin's expert report, cited at page 3 of the judgment, concluded that though not expressly listed, the substance had similar chemical structures and pharmacological effects to other prohibited stimulants under Article 4 of the IOC rules. Furthermore, following the 2005 US and Belco case, what the arbitrator noted about new and emerging drugs is especially important in our case. It noted that it will be impracticable to find all forms of steroids in the list of prohibited substances, and they're restricting prohibition to certain named substances will be both unfair and detrimental to the sport, noting that in that case, new drugs can be easily developed that would similarly possess similar pharmacological effects to drugs that are listed inside the WADA code. And yet, because it isn't it's not explicitly prohibited, therefore, athletes are able to consume them and get an advantage and not be sanctioned. Ultimately, this approach, finally, in the CS case of Egg Athens and Slavia Prague, it recognized that the autonomy of sports governing bodies and confirmed that CS jurisprudence forms a transnational lex sportiva providing uniform standards. This autonomy allows event organizers and disciplinary bodies to interpret and enforce rules to protect competition integrity, so long as they act proportionally and act within their regulations, as the GDC did here by applying Rule 12 in our case. Applying these principles, GDC's decision was reasonable and proportionate. Bluebet, while not yet on the WADA prohibited list, demonstrably enhanced cognitive focus and stamina, creating an unfair advantage to Mr. Lander.
Counsel, you referred to Rule 12 of the qualifying games rules, right?
Yes, Mr. Arbitrator.
Yeah. Can you just help me understand what it means by the spirit of the sport?
Certainly, Mr. Arbitrator. Apologies, Mr. Arbitrator. That will be an issue that I will have to get back to you on. I note my time, and unless I may be of further assistance on the last issue.
Yeah, I'm okay.
Thank you, Mr. Arbitrator. Apologies.
Mr. Arbitrator, members of the tribunal, my name is Brandon Zhang, and I appear for the respondent, the Games Disciplinary Commission. I will be speaking for 14 minutes on issues B and C. I will address the second issue, whether GDC erred in seating the tribunal outside the host country. We submit the GDC acted properly, lawfully, and fairly. The seat was validly chosen in accordance with the agreed upon rules. It was practically necessary given that the riots in the host city of Rabbutana, as well, there was no prejudice or unfairness that resulted. The qualifying game rules 23, subparagraph 1 and 2 requires the dispute to be heard in the country where practicable, and within a week in the host country where reasonably practicable. The flexibility of reasonably practicable in our case is therefore built in. The tournament agreement was signed by all the athletes, including the appellants, and it incorporated these rules. Participation itself constituted consent. Furthermore, the CAS Code Rule 28 sets Lausanne as the default but expressly permits departure where the parties have agreed otherwise. And in the present case, they did through Rule 23. And lastly, Lex Sportiva, which is the principle of party autonomy. Sports arbitration recognizes the autonomy of federations and athletes to structure procedures, provided that the fairness is preserved. Mr. Arbitrator, the first point is that the parties consented to the framework. In Matu Zalim versus FIFA, CAS decision 2008, A1519, a footballer challenged sanctions after breaching a contract. The tribunal, at paragraphs 4 to 6, explained that the seat determines the lex arbitri, the national law of the arbitration, but crucially that the parties agree on procedure is controlling. And just as CAS enforced the parties' chosen framework in that case, in the present case too, the athletes signed up to Rule 23's flexible seat clause in the tournament agreement. And similarly, in CAS decision 2011 A2425, a FIFA official appealed a corruption ban. CAS upheld a non-Lausanne seat because the parties had accepted FIFA's rules providing for it.
Counsel, you said that parties signed up to this Rule 23. Where's the evidence of that?
Mr. Arbitrator, I meant to say Rule 23 of the game qualifying rules.
Okay, but you said parties consented. So where can I see that parties consented? Is it really a matter of parties consenting by signing or what?
1 minute, Mr. Arbitrator. Mr. Arbitrator, I don't have the facts in front of me, Mr. Arbitrator. I may be able to assist at a later moment.
Okay.
Apologies, Mr. Arbitrator. By analogy, the having consented, they cannot now disown it simply because they dislike the outcome. Second, the seating the tribunal outside the host country was not only valid, but necessary. The facts, on the facts at paragraph 25, immediately after the tournament, massive riots broke out in Rambutana, the host city. And these lasted several days, right inside the 1 week window within Rule 23, subparagraph 2 for convening the tribunal. It was simply not practicable to seat a tribunal in the city, which was heavily gripped by civil unrest. The GDC therefore chose to convene the hearing at the Global Games headquartered in South Nankaland, paragraph 29, a secure and neutral administrative base that serves as the international headquarters for the federation itself. And this was faithful pursuant to Rule 23's language where reasonably practicable. The riots made the host city unsafe, so the global headquarters was the only practical and secure seat. This decision upholds the principle of lex sportiva and includes the values of safety, timeliness, and accessibility. Sports arbitration does not operate in a vacuum. Procedural rules must be interpreted pragmatically to ensure that the hearings are safe, timely, and fair.
So, Counsel, for Rule 23, I do see that what you cited, reasonably practicable, is inside the sub-provision itself of sub-provision 2. But sub-provision 1 also says where it's practicable to do so. Is there a difference between these two standards or what?
Mr. Arbitrator, subparagraph 1 pertains to the timing, where reasonably as soon as possible. And in our case, we submit that we did in fact provide and set up agree to the tribunal as soon as possible. I believe it was about a week after, within the time frame. And subparagraph 2 pertains to the location. And in our case, it was not feasible because the city was under riots, and therefore we had to choose another jurisdiction, Mr. Arbitrator. And now I will turn to prayer C, whether the GDC had erred in deciding that Ms. Tangs is ineligible to participate in the qualifying games. Mr. President, we submit that the GDC correctly found Ms. Tang ineligible to participate in the qualifying games. Under Rule 3 of the qualifying games, this representation must require a real and effective connection to the nation that enters, and Ms. Tang's lacked that connection.
Sorry, where are you citing that proposition from?
Rule 3 of the qualifying games requires athletes to be either citizens or permanent residents of a country in Asia. And CAS jurisprudence, such as in the 2009 A19110 Telecom Egypt Club case, held at paragraph 33 that the panel is to interpret provisions in a manner which seeks to discern the purpose and intention of the rule maker. And here, in the present case, the rule makers, essentially, the purpose was to limit and have participants be of an Asian ethnicity or a permanent residence in an Asian country. And on the facts, Ms. Tangs holds dual citizenship, and we submit that this dilutes the Rule 3, because not only does she have another allegiance to another country, she also was not born in an Asian country, so ethnically she is also not Asian, Mr. President.
I'm sorry, ethnically she's not Asian. Well, what is she again?
She holds two citizenships. One is Oceania citizenship, and the other citizenship is Asian citizenship.
So how does this relate to ethnicity?
Well, Rule 3 requires Asian. The GDC held that she was ineligible because she was not 100% Asian, and the intention of the rule makers is for only Asian participants to participate in the games.
Can you define ethnicity for me? Because that was a submission you made.
Ethnicity is essentially the genetic makeup of an individual.
Are you sure, Counsel? Genetic
is the quality of or fact of belonging to a population or subgroup made of people that share a common descent.
Descent. I see.
Right. And on the fact she's a descendant of an Oceania country, Mr. Arbitrator. This is our submission. And that the purpose of Rule 3 was the rule makers wanted it just to be an Asian game for Asian athletes. And Mr. Arbitrator, turning to my next point is that we submit that Ms. Tang had no close, genuine connection with the country of Duriana. In CAS decision 98-215 at paragraph 27, the panel said that a person may have two or more nationalities, but every athlete can only have one sporting nationality. And Mr. Arbitrator, there's a difference between sporting nationality and legal citizenship. Sporting nationality is essentially the allegiance that an athlete has towards a country. And this follows the CAS jurisprudence. In the case of CAS OG00-001, Mr. Angel Perez versus IOC at paragraph 1720, the tribunal cited the Notenbaum case. In that case, Mr. Notenbaum, who was a German national, while on a visit to Europe, obtained Liechtenstein citizenship. And the court ultimately held that even though he had a legal citizenship to Liechtenstein, that this was not, in fact, not based on a genuine prior link, and therefore the claim was inadmissible. And in the present case, this is exactly the case. At paragraph, in the compromise at paragraph 32, she recently moved to the country, and jurisprudence in the case of 2017 1377 Melody Rinaldi versus FINA, at paragraph 36, the panel affirmed that a real change to prevent what's called nation shopping needs to correspond to the activities, the athlete's activities in her everyday life. And in that case, even though Melanie and in the other case of Perez, they both resided in the US, and in this Melanie case, she resided in Portugal for years, they still held that there was no citizenship, or even though they had citizenship, the court held that they still didn't have what's called the sport nationality based on a real genuine connection to the country. Even so, the jurisprudence is that even by merely residing in the country is not in itself sufficient to prove what's called a sport nationality. In other words, to prove allegiance to the country. And simply having a passport, it will not prove to be sufficient based on the jurisprudence. And lastly, Mr. Tribunal, just to summarize up here, eligibility is not about formalities, but based on genuine connection. And the cases in Notenbaum, in Mr. Perez and Rinaldi shows that the GDC rightly required Ms. Tangs to demonstrate an effective nationality, one that's grounded in a real genuine connection with residents, as well as participation in everyday life. Its decision in denying her participation in eligibility was lawful, reasoned, and proportionate, and follows a long line of CAS jurisprudence. We therefore respectfully pray that Prayer C be dismissed and GDC's position be upheld as consistent with CAS precedent based on the facts of the case. Thank you. This concludes my submissions, Mr. Arbitrator.
Okay, then we switch the yeah. I think unless you want to do the rebuttal, no. Or Mark does the rebuttal, you can go talk to him. Yeah, I can do the first rebuttal. Mr. Arbitrator.
Yep, go on.
Mr. Arbitrator, one point in rebuttal. We note that the respondent has raised the issue of a lack of disclosure, noting that it wouldn't amount to a finding of impartiality. This is incorrect. In the case of AVB Supreme Court, it noted that a coach that brought a claim before the FIFA players, which was competent according to FIFA regulations for disputes of an international dimension, noted that a Croatian arbitrator declared for the first time during his deliberation that he was one of 12 arbitrators of the CFF tribunal in a previous case involving the appellant. Notably, The courts found that his independence was in question and decided to annul the award. Therefore, the lack of a disclosure in that case has clearly amounted to the fact or finding that there was a lack of independence of an arbitrator because this shows dishonesty, and therefore the arbitration award should have been annulled. And applying the same maxim to our case, the fact that Miss Farina and Mr. Douglas both failed to simply mention to the GDC that they are a prior relationship with Miss Tanks, no matter how small or big, and this lack of disclosure should be a finding of their lack of biasness, and this court, and therefore the quorum was biased. Unless I may be of further assistance.
Nope.
This concludes my submissions. Thank you, Mr. Arbitrator. Yeah.
Mr. Arbitrator, I would like to rebut my counsel's arguments by saying that the lack of disclosure did not evince a lack of independence or the lack of impartiality. In the case of A and FIFA, it was held that the repeated non-disclosure was appropriate but not evidence of partiality. Similarly, Ms. Farina believed her familial link was public knowledge according to the compromise paragraph 27, and Mr. Douglas's public gamer association were widely known, negating the deliberate concealment. The Swiss case law of XSA and Y, which was held in 2001, recognized omission based on the perceived irrelevance as a valid defense. I would like to conclude my submission over here, Mr. President. Thank you.
Very go outside.
Yeah. Wait, that's all, is it?
Yeah.
Okay.